Portfield. USB, which I transferred constables of his.
Court is calling 2020.
Okay, that intro might have been calm, but don't get too cozy. This courtroom is about to get real. Also, keep an eye on the defendant's demeanor as the charges are read. Body language speaks volumes.
5CR005277 State versus Luis Lucas. Could I have parties announced?
Your opinion for the state of Texas. Michael Collins, attorney for defendant, present and ready, Your Honor.
Are you Mr. Lucas?
No.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
The court will find that the state is in compliance with discovery. Mr. Lucas, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, ma'am.
You're charged with violation, bond, a protective order, assault, stalking.
2 to 10 years. In prison, and up to a $10,000 fine. That's no slap on the wrist. Here's a quick question. If you were facing that kind of time, would you risk a plea deal or take it to trial? Let me know in the comments.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, and I believe he was, Your Honor.
Mr. Lucas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 PF.
This is a big one. That affirmative finding of family violence doesn't just impact sentencing, it triggers federal restrictions on firearm ownership. Meaning, no guns, no ammo, and no custodial rights. That label sticks for life.
00972. There's an affirmative finding of family violence and no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition or be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes.
Defense is at the plea.
Yes, I had spoken to Rick about it with the no contact order. We were just going to ask for a slight little change to it. Basically,
What I can tell you is the court is going to order no contact. So if that's something that is a deal breaker for you all, then that's a deal breaker for you. But I'm not going to remove the no contact order.
Hey, yes, ma'am.
Do you still wish to go forward with this plea? All right, state is at the plea.
it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel at the meeting, such motions.
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours community service restitution, the BIPP, and TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
Yes, Your Honor, at this time, table offering evidence is Exhibit 1 with all attachments.
I reviewed that with my client, Your Honor. We have no objections.
All right, did you review the waiver? Oh, have you spoken to the complainant?
Yes, we have, Your Honor.
All right, thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right?
Assault on a pregnant woman? That elevates the emotional and legal stakes dramatically. And just wait, the judge is about to go from courtroom official to moral compass. Buckle up.
For you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sure.
All right. So according to the police report, it says this was assault of a pregnant person. I'm assuming she was pregnant. Well, is she currently pregnant? Was she pregnant during this?
At the time, yes, ma'am.
All right. So are you in love with her?
We're supposed to be getting married.
Well, not on my watch. That marriage is off. You can't have any contact with her.
You told me, ma'am.
I mean, I don't understand. If you love her, then why are you putting her hands on her in violence? And at Kentucky Fried Chicken, no less.
When I understood it was dismissed, ma'am, that didn't happen.
Oh, well, let me just tell you what it says in the police report. The victim told dispatcher she was being assaulted by her boyfriend at the restaurant. I made contact with the victim while she was outside the vehicle. Victim stated suspect assaulted her before. Victim stated that there is a no contact order in place. While victim was in the drive-thru ordering food, victim stated suspect showed up to the incident location on foot. Victim stated suspect started arguing with her through her car window, telling her they need to get back together. Victim continued to argue with suspect. Then victim stated suspect punched her 3 times while he was standing outside the vehicle. I could see redness on victim's cheek and dry
That wasn't just sentencing. That was a soul check from the bench. And if you thought judges only deal in legal code, this one's delivering reality checks too.
blood on her lips. Victim stated that she would be willing to make a statement. I guess she's changed her mind or you've talked to her. And then it says suspect refused to tell me his birthday. He ended up getting your birthday from the victim. Shortly after, suspect stated he came to the location with victim. Suspect stated that he is aware there's a no contact order between him and the victim. So you're still violating protective orders. So what I'm telling you is for the 4 years that you're on deferred adjudication in this court, you're not getting married to her because you're not having contact. And I'm not going to allow you to get married to her by proxy. Maybe during these four years where she has no contact with you, she'll be able to reflect that she can do better. So it's 4 years deferred adjudication, a $1,500 fine probated, affirmative finding of family violence. There's to be no contact with the complainant. If the complainant comes to your house trying to get back together with you, you better call the police and say that you have a no contact order. If she calls you and says, let's get back together, don't go over to her house because I'm telling you can't have any contact with her. Do you understand?
Yes, ma'am.
Do you have any children with her other than maybe the one?
Yes, no, ma'am. Other than that.
Do you have any other children other than the one with her?
Yes, ma'am.
And how many other children do you have?
I got 7 altogether.
All right, and what are their ages?
I really don't got custody of them, so I don't really.
Well, what are their ages?
I'm not sure, ma'am. I don't got custody of them.
So you're just being fruitful and multiplying. Okay.
Young at the moment.
How old were you with your first child?
19, I believe.
All right. And how old are you now?
30.
And are you employed?
I was, but we came up here for vacation, so I'm not currently.
Doing what?
We was up here for New Year's.
You came up here for a few years for vacation?
New Year's.
New Year's. And never left?
So I got locked up.
All right. 4 years deferred adjudication, as I previously stated, $1,500 fine, probated, affirmative finding of family violence, no contact with the complainant, regular reporting by Zoom or in person, regular random UAs, BIP, TAP evaluation in custody, follow recommendations, proof of employment within 30 days of release, no employment as a home health care provider or with minors, no unsupervised contact with minors, 100 hours of community service restitution. The court is going to order parenting classes. Once that's completed, parenting classes will be, the community service hours will be deemed satisfied. GPS partial for employment. until further notice. And field visits 1 time per month until further notice. Probation, is there anything else?
That yes, going through the jail judge.
Yes, waive fees and taking in consideration 2025 PF 00972.
Excuse me.
Mhm.
On the GPS, I didn't know I was going on the GPS.
Oh, yeah, you're going to be on GPS because I need to know where you are.
I don't know. Oh,
Right. He doesn't have an address.
Oh, they'll work with him on getting him an address.
I ain't got no choice but to say.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yep, she's repeating the gun restriction, because many defendants act like that part doesn't apply to them. Spoiler alert, it does. And violations lead to federal charges, no joke.
Yes, ma'am.
Because it's a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived, I'm sorry, I need that. And because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am. But this is just for the bond, breaking bond.
No, this is for your being on probation. You're going to be on GPS in this court until further notice.